Welcome to another one of our members' education sessions. I'm Chris Carrigan, the data advisor for Use by Data, and I'm part of the secretariat for Use by Data. As you know, we put these on, hopefully we put these on once every few weeks. The suggestions all come from our members or something that's perhaps been in the news or the media, something which is topical. So feel free to keep your suggestions for topics going. This morning's session is the second of two around aspects of the law relating to the ways in which our patient data can be used. This session is going to look at issues around the concept of anonymisation. It's ways which our data can be changed to protect our identities, which allows researchers to then use the data to do their work. Let's get started. I'd like to welcome back Edel and Cassie from Health Data Research UK, who have been really helpful in putting these two sessions together. We've been trying to get these done for a while, so really grateful for them for their time putting the sessions together. And I'll now let them introduce themselves again and hand over to them now.
Hi, morning everyone. Fantastic to be here. I'm Cassie Smith. I'm the Director of Legal Trust and Ethics for Health Data Research UK. Over to Edel.
Sorry, brief technical issues. I'm Edel McNamara. I'm the Data Protection and Information Governance Lead working with Cassie at Health Data Research UK. Thanks.
Can everyone see this, the slides okay? Great. So I'll make a start and then hand over to Edel for the second part of the session. So we're going to talk about the ICO anonymisation guidance, and as Chris said at the start, how data can be rendered anonymous to protect identities. Next slide, please, Edel. Before we dive into the detail around the guidance, just wanted to start with explaining some key concepts. Some of you might be familiar with these, so apologies for the recap. But before diving into the detail of the guidance, I thought it was just important to make sure that everyone understood some of these key concepts. So the legal framework, first of all, around data protection law. There's a few different pieces of legislation that form the data protection framework in UK law. So we've got UK GDPR, which we hear about quite frequently. This is a piece of legislation that provides the core principles for protecting and accessing data. And then we have the Data Protection Act 2018, which is a piece of UK legislation which implements the UK GDPR into UK law, but also expands on it. So it details things like exceptions, the rights that you have as an individual over your data, such as rights to ask for copies of your data. And it also gives powers to the regulator, which is the Information Commissioner's Office, the regulator in the UK for data protection. And it also gives powers for the ICO to produce guidance. And this guidance isn't part of the law, but it's guidance on how to comply with the data protection principles. So that's the reason why we're here today. The ICO has produced some new guidance specifically around anonymisation that we're going to look at. Next slide, please, Edel. There are some key definitions in the legislation. And again, you've probably heard of these, but I just wanted to run through them to make sure we all have an understanding of these key concepts. So the first one is personal data. And this is defined as data that identifies living individuals directly or indirectly. So it could be your name, but it also could be a combination of characteristics, such as location, address, health conditions, and other things that can identify you. And then we have pseudonymous data. So this is data where direct identifiers have been removed and usually replaced with some kind of key. So for example, this could be some of your health record information, which has had your name and address removed from it, but potentially still has some identifying characteristics about you. Sometimes we hear the term de-identified used. So just a note to say that the new ICO guidance that we're talking about today does discourage the use of the term de-identified. That's not the term that the law uses, it uses pseudonymous. So the ICO has issued, I guess, a strong plea to say, please stick to the legal definitions and use pseudonymous. I think there are pros and cons of this because de-identified is a little more understandable, but the regulator feels that the correct terminology of pseudonymous should be used. And then we have anonymous data. So that's data that can't be linked to any individual, even when combined with other data. So this could, for example, be statistical counts, percentages of people with a particular health condition, for example, where no one individual can be identified. And then we have anonymisation, and that's the process of taking data that is personal and making it anonymous. And in reality, identifiability is a lot less clear-cut, and Edel's going to come on to explain that anonymisation is a bit of a spectrum, and there's some judgment involved in determining whether your data is personal or whether you've done enough to make it anonymous. Next slide, please, Edel. The data protection legislation also sets out roles. So these are the other important key concepts to be aware of under data protection law. So we have controllers, and the controllers are ultimately in charge of the data. So they decide what happens to it. So this could, for example, be an NHS trust that has your data and determines what they do with it, how they use it for your care, and whether it's used for research. And then we have processors, and processors are organizations that handle data on behalf of the controllers. So that could be, for example, if an organization uses a particular system to store their data, they could be a processor acting on behalf of the controller. Then we have a concept of joint controllers. So these are two organizations or individuals jointly deciding how data could be used. So for example, this could be two universities jointly collaborate to do some health research, and together they're designing that research, deciding how that data is used and what's going to happen to it. They would be considered joint controllers because they're taking those decisions together. And then finally, we have the data subjects. That's us, the individual that the data relates to. And under data protection laws, as a data subject, you have some rights over how your data is used. Next slide, please. Another relevant concept just to be aware of before we dive into the detail is trusted research environments, also known as safe havens, secure data environments, and various other names used to describe a secure system which provides access to health data. So the idea that the data doesn't come to you when you're looking to access it for research, you're going to the data stays in a central system with access controls, and you're going to the data to use your research. This isn't a legal concept, but it is something to be considered when you're considering whether data is anonymous or not, because trusted research environments, secure data environments provide important safeguards that help you assess whether there is a real risk of re-identification of data. Next slide, please. So onto the guidance, and one more, Edel. Thank you. So key points in the anonymisation guidance that we're going to run through today. So we're going to run through some welcome points, some points that we like in the guidance, just at a high level. And then we've picked aspects of the guidance that we think are most relevant to use of data for research. So looking at anonymisation and the spectrum of anonymisation, and how you go about determining whether data is going to be considered sufficiently anonymous that it's no longer personal data for legal purposes. So you look at various different tests, and we'll come on to talk about those different aspects of how you assess identifiability. Next slide, please. So starting with the welcome points, we think it's great that the ICO has published some guidance. It was much needed. It isn't straightforward to determine at what point you've done enough to data. Have you removed enough data points and anonymized it enough to ensure that it's sufficiently protected for research? So we think that's helpful. We think that the firm guidance regarding terminology is helpful. At the moment, the terms pseudonymous, de-identified, and various other terms are used, and hearing what the ICO feels is the correct terminology, even though it's not necessarily what everyone is using, moving towards alignment on terminology is helpful. And the guidance is contextual, so there is some guidance around how you apply this in practice. Although we were a bit sad to see that there isn't specific guidance yet around trusted research environments. And then there are some high-level case studies and relevant examples, but we are working with the ICO to hopefully produce some more detailed examples, which will be more helpful for the research community. So overall, we think it's welcome that there is some guidance on this, but more could be done to provide some more granular case studies which look perhaps specifically at the healthcare context. Next slide. So coming on to the detail of what we wanted to cover in this session, what does anonymised really mean? And the key points from the guidance and from the law are that it's really context dependent. It's not just about what you've done to the data, whether you've removed names and addresses and how much you've done to the data to render it anonymous. It's also about the controls around the data. So you can consider who is accessing it and why. So the risk of re-identification would be less, for example, if someone is a professional researcher who's been through data security training, you can consider where the data is. And it's also a risk-based approach, which looks at likelihood of an individual being identified. So it's not an absolute test. The law is not that it must be impossible to identify somebody. You look at the likelihood, the motivations, where the data is, and you look at it very holistically. But there are some common myths sort of debunked strongly in the guidance. So removing names is not anonymisation. If you've got an individual health record and you just take their name off it, there is probably enough identifying information there that were it to be put in the public domain, it would be identifiable as that person. So identifying, removing just identifiers, name, address is not sufficient. And pseudonymization, again, is not anonymization. You need to look at all the controls, not just the nature of the data itself, but the who, the where, and all the controls around that. And with that, I'm going to hand over to Edel.
Thanks very much, Cassie. Great. I'll start off with kind of identifiability of data exists on a spectrum, and it can sometimes be difficult to tell whether data is anonymous or not. So on this spectrum, we have personal data on one end and anonymised data on the other. In between both of these extremes, information or data may be considered closer to one end or the other, depending on the context, such as the data itself and the environment, and who is accessing it. The new guidance is explicit that individual level data can still be considered anonymous under the guidance. So this is kind of very good, especially when accessing data within trusted research environments. Often you will see pseudonymized or de-identified data, which would not be, like, a researcher would not be able to re-identify, but might be identifiable in the hands of the person who is sharing the data. So it's great to see that data can be considered effectively anonymous. I just note here as well that the guidance needs to be read in full, as there's kind of a risk of different interpretations if you only look at specific sections. So on to the first test, which is the whose hands approach. This test applies when sharing data with independent organizations, and this test focuses on who is receiving the data and how much risk of re-identification they bring based on their role, motive, and access. It's a two-step assessment in the guidance. So firstly, you check what the relationship between the parties are, whether they're a joint controller, controller and processor, or two independent controllers. And then you assess if it's reasonably likely that these people are able to re-identify the participants. And it's just important to note that the whose hands approach only applies when sharing data to independent organizations. This means that parties who are joint controllers or controller processors, the data will always have the same status, e.g. if it's anonymous or personal data. So we've tried to highlight this within the slide here. So firstly, we have an example of a data controller or data processor. So an example of this is where, say, a company might host data on, say, Microsoft or cloud storage. This is kind of a controller and processor relationship, and therefore if the data is personal data to the data controller, it also will be considered personal data to the data processor. Secondly, you have where a joint controller relationship. An example of this is two universities jointly designing and conducting research. If the data is considered personal data to Joint Controller A, it means it will have to be considered personal data to Joint Controller B, no matter what they access. And then just on the other side of the slide, we just note here where data can have a different status and where the application of the whose hands assessment applies. So an example of this is a researcher accessing data within a trusted research environment. A trusted research environment might grant access to a researcher. You can apply the whose hands assessment here because there's an independent data controller relationship. Both parties are accessing the data or using their data for their own purposes. So the data can be considered personal data to the host organization or the trusted research environment, but it's considered anonymous data to the researcher who's accessing it. The reasonably likely test. So organizations must be able to demonstrate that disclosing or sharing apparently anonymous information will not lead to inappropriate disclosures of personal data. Therefore, you must assess the risk of the information being re-identified. The reasonably likely test is a key part of this process, and it helps determine if data has been anonymised effectively. The test has two parts. Firstly, do you have the means that are reasonably likely to be used to identify people? And then if the information is not is personal data in your hands, then are these means reasonably likely to be used by other people to identify this information? If there are means reasonably likely to identify someone, then the data is personal data. And if there are no means reasonably likely to use, then this information is anonymous. Reasonably likely isn't a very strict phrase, but it's one that has a lot of note in GDPR. And it's a practical, more risk-based approach. So under this, you do not need to consider every hypothetical chance of identifiability, as it's not always practical or possible to reduce this to zero, and the law doesn't require it. It's important that organizations assess what is reasonably likely in the circumstances, and therefore it's focused on real-world risks and practical applications. So we have an infographic of this here, and on one side we have kind of personal data, which is easy to highlight, that personal data is directly identifiable or indirectly identifiable, and data protection law applies. And on the other extreme, we have anonymous information where data protection law does not apply. In the middle is where it gets a little bit more tricky, and that's highlighted within this section from the ICO. This is a snip from the ICO guidance itself. So overall, when assessing this, organizations need to consider the means reasonably likely to be used, considering the data and the environment itself, the context, scope and purpose of processing, and any technical measures that may apply. This also needs to be assessed in line with objective factors such as motivation, competence, available technology, and the likelihood of use. I'll speak a little bit more about some of these concepts in a moment. It's also important to note that the greater the likelihood that someone might attempt to re-identify a person within a data set, so the more valuable the data might be, or if it might be more valuable for somebody to re-identify it, the more care organizations need to take to ensure that anonymization is effective. This test involves an element of judgment and involves a risk review of the organization that is sharing the data. It's a very timely thing to speak here today because yesterday this approach was affirmed by the EU Court of Justice. So they released something that I think Cassie and I and a few others have been long awaiting, kind of this judgment, but they noticed that pseudonymized data could be considered anonymous following the means reasonably likely assessment. This is very welcome news as firstly, the UK aligns with this position, and secondly, there were concerns that the court might take a more strict or absolutist approach in which some European countries have taken. For example, France have said that if data can be re-identified at all by any party, it can never be anonymous in anyone's hands. So as I said, this is very welcome news, especially in the context of research, where access is often granted to data to researchers within trusted research environments via secure methods and with other safeguards in place. Next. Data protection law itself does not specify how you determine whether anonymous information is likely to result in re-identification, and there's a number of tests that need to be considered. The motivated intruder test is another one of them. So one must consider all the practical steps and means reasonably likely to be used by someone motivated to identify people whose data was used to create anonymous information. So the motivated intruder test asks, can a determined person re-identify someone in the data? This test is explicit in the guidance and must be used, but it is not no. So when applying this, you must assume that a motivated intruder is reasonably competent, has access to appropriate resources, and uses investigative techniques, such as making inquiries to people who might have more information or advertising for anyone with more knowledge to come forward. And this is checking how a determined person, e.g. kind of like a journalist or a stalker, are examples that the ICO give, and it should also consider if they're likely to use any specialist resources. Additionally, when applying this test, you need to consider the relationship between the intruder and the person the data relates to, any background knowledge, and whether the attack is targeted, if the intruder knows for certain any information about the person the data relates to, and the perceived value of the data. The ICO also notes that the more widely used and cost-effective methods become, the more they should be considered likely to be used. A recent example of this is generative AI tools can now be used by motivated intruders to find and re-identify personal data. So it's crucial that they're considered as a part of an assessment when one is making the motivated intruder test. With the reasonably likely test and the motivated intruder test as well, there's an element of judgment and risk assessment, as with all of these matters. Within the motivated intruder test, there is a specific exemption to it, and this is for professions with prior knowledge and jobs that impose strict ethical and confidentiality conduct rules upon them. So an example of this would be in finance or medical professionals. However, it goes on to note that one should consider any possible circumstances where people in these professions may be motivated to break these rules, so for financial gain. This is a new part of the guidance, which is, I think it's good to see the exemptions exist and laid out for specific professions. However, it's difficult to see how you would apply this in practice, and the guidance doesn't note what information you would be required to look at and required to check when assessing this. And then lastly, as a part of the reasonably likely test and overall, the guidance notes that you need to reassess the risk of identification if there are new attacks or vulnerabilities, if new data sets are released which could increase the risk of re-identification, or before you grant access to any new people. This can be challenging, specifically within the context of trusted research environments. There are already processes existing when granting access to new researchers within a trusted research environment, following the 5 safes and the Safe People principle. These ensure that people have appropriate training to access and use the data, and this new test doesn't align with this. It could be very costly or time-consuming to reevaluate and relook at all of the anonymisation tests and risks when granting access to each new recipient. That's the detail we have provided upon anonymisation. I'm aware there's kind of a lot of information we have given and a lot of different aspects and tests towards anonymisation we've spoken about. So I think we'd like to open up the floor now for any kind of clarifying questions or anything else. Thank you.
Yeah, Cassie, thank you for that. That was a really, really good run through of complex subjects. I'd like to say a massive thank you for Cassie Edel for going through something which is quite complex in a really, really clear way. I thought those slides, that presentation was really helpful. Sparked a load of things in my mind. Clearly, it sparked loads of questions as well. Thank you to everybody else for their questions and everything else. We'll put the first 20 minutes of the discussion on the web. I've grabbed a copy of the slide that Abby put up, and I'm going to follow up with Abby and Linda about talking with a couple of SDs and getting them to come to a session with us about how they work in the wider context. Whether that'll be an education session or something else, I don't know. We'll have to think. But I will follow that one up. And yeah, thank you. I think it's probably it. You're free to return and go and have a well-deserved cup of coffee after that. A really good, helpful session. Thank you to everybody. Have a lovely weekend. I'm off to the Great North Run on Sunday. You will watch me on telly as I sail past the finish.
Good luck. Fantastic.
Thank you to all. Good luck.
Thanks, Chris, as well.
Take care all.
Bye.
Thanks again. Bye.